I don't want to enter into predictability of what Michael Wood will say, but I will limit myself to present our first discussant, and which is King Counsellor and barrister at 20 Essex in London, where he practices very actively the field of public international law. He was legal advisor to the UK Foreign and Commonwealth Office, and he was a member of the UN International Law Commission. Sir Michael Wood, the floor is yours.
Like others, I'd like to thank all the organizers for the invitation to this excellent conference, and also all those who've been working very hard here in Seoul to make it run so smoothly. Like others, I'd like to make it clear that I'm not speaking on behalf of anyone other than myself, certainly not on behalf of any clients I may have or have had, including Colombia, who were very successful in the last case that Nicaragua brought against them. I'd very much like to thank our two speakers for their very rich and thought-provoking papers. And Professor Magnússon is right. I'm going to disagree with almost everything that he, but also that Sir Malcolm Evans said. I think they've raised very very interesting questions about what I shall still call the regime of the continental shelf, subject to Malcolm's views on that, of course. I do think, I agree with Malcolm Evans that it's wrong to refer to, or it's not helpful to refer to UNCLOS as a constitution for the oceans, except in rhetorical terms. I don't think it brings anything legal to the picture. I do, however, find it useful to refer to it as a living instrument, despite the fact that that term is much hated in the United Kingdom by all those, and there are rather many of them, who are opposed to the European Convention on Human Rights. But it's a useful concept in this context. Professor Evans, to begin with him, seems to accept, perhaps reluctantly in some respects, that the current law on the continental shelf is reflected in the Convention, including in particular Part 6. That's obviously the case as between the states parties to UNCLOS. I think it's broadly the case that the law reflected in UNCLOS applies as between and with non-parties as customary international law, as international courts and tribunals have consistently held. And I think that we can leave aside, because it very rarely will occur, what's the law applicable as between those few states who are not parties to UNCLOS but remain parties to the 1958 Convention on the Continental Shelf. Though there again, I think a case can be made for concluding that the 1958 Convention has been in many respects superseded by the international law reflected in UNCLOS. Professor Evans seems to accept that there is not going to be an amending or implementing agreement on the continental shelf, completely upending it, though that seems to be what he would like to achieve, or at least he foresees might be necessary. He concludes from this that, to use his words, we have to work within the framework that the treaty, that the convention provides, subject to interpretation. I would actually put it rather more directly. In my opinion, we as lawyers should acknowledge that the law is as set out in the convention, which has to be interpreted in good faith in accordance with the Vienna rules, and that was discussed in the earlier panel today. Professor Sir Malcolm Evans then refers to what he calls some of the most significant issues that we currently face regarding the continental shelf. And I'm not convinced that we do necessarily need to face all the issues that he refers to under his heading now. In an ideal world, perhaps, but international law does not inhabit an ideal world. Not even the law of the sea inhabits an ideal world, I'm afraid. I note that Professor Evans accepts, somewhat reluctantly perhaps, that the outer limit of the continental shelf is what it is. And he does not seem to challenge the ICJ's decision of 2023, even if he may not be totally impressed by the court's reasoning. Professor Evans makes the valid point that the court's 2023 decision may shift attention to the baselines for measuring maritime zones. But he goes on to suggest that greater clarity on baselines would doubtless be welcome. I'm not so sure that greater clarity is needed in the provisions of Section 2 of Part 2 of UNCLOS, a part, that is, from the question raised concerning whether baselines are static or ambulatory. The general law on baselines seems to me to be pretty clear, as Judge ad hoc McRae demonstrated in some detail as regards straight baselines in his dissenting opinion in the 2022 alleged violations case between Nicaragua and Colombia. Nor am I convinced that we should try to clarify the meaning of Article 121, paragraph 3, on rocks which cannot sustain human habitation or economic life of their own. That is a question that arises relatively rarely in practice. Even in delimitation cases, it can usually be avoided, as was done in the Black Sea case. So when the issue does arise, solutions are usually found. To seek to refine the meaning of Article 121, paragraph 3, in the abstract might, I suggest, prove fruitless, and it might even provoke disputes. The question of such rocks potentially raises very sensitive matters for quite a few states. This may be one of those cases where matters are best left unclear. The same goes, I would suggest, for the definition of low tide elevations and some of the other matters that he refers to under the heading now. I think these are largely issues that can be resolved by one by one as necessary. Nor do I agree with what Professor Evans said about grey areas. As I'll explain when I come to Professor Magnusson's paper, I do not, in fact, read the 2023 Nicaragua-Colombia judgment as complicating the issues of grey areas. What I suggest risks complicating the matter is to misread the judgment. I don't have a great deal to say at this stage about the issues raised by Professor Evans concerning the future. I would suggest that most of these problems, such as protecting cables and pipelines at sea, can be resolved within the existing framework of UNCLOS, the living instrument. The convention has shown itself to be very adaptable. Minister Kang this morning referred to, and I agree, the convention's resilience and enduring relevance. I agree with what Professor Lalonde said in her approach earlier this afternoon. Any adaptation, of course, has to be done with a good understanding of the law of the sea and to go with the grain of the convention, as my colleague David Anderson likes to put it. We do not need to address the questions that Professor Evans has pointed to with a sledgehammer or have some kind of bonfire of existing rules. I'm not suggesting he was suggesting that, but I rather got that flavor. So I've left myself a little time to address Professor Magnusson's paper, which he's looking forward to, I think. I disagree quite strongly with his thesis. I found his differentiation between type 1 and type 2 cases overlap very helpful. But it seems to me that that's precisely what the ICJ was doing in the 2023 judgment, though perhaps it could have done it more clearly. The 2023 judgment seems to me to be noteworthy for at least three reasons. Firstly, procedurally, in an unusual, controversial, but very effective procedure, the court ordered, just 2 months before the hearing that had already been scheduled on the merits, that the parties should limit their arguments exclusively to 2 legal questions about customary international law. Of course, I was delighted. In the event, the court only needed to answer one of the questions. The procedural decision was controversial, but I think it proved to be of great advantage. It considerably simplified the oral phase of the case. The order with the procedural decision was adopted without dissent, though there was an important joint declaration by 5 members of the ICJ raising questions, indeed strong doubts, about what they were agreeing to. However, in his own declaration, Judge Abraham very helpfully explained in detail why this was a sensible procedural decision in this case. That's the first interest of the judgment. Secondly, in the event the court only found it necessary to answer one of the 2 legal questions it had posed, and the precise question, I'd better read it out. Under customary international law, may a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of its territorial sea is measured extend within 200 nautical miles from the baselines of another state? And its answer to that question ended the case in Colombia's favor. I would point out that Nicaragua accepted the judgment on the very same day that it was given, so it resolved the issue as between the parties. The court's clear response to this one question has led to some strong criticism, including from dissenting judges on the court, and including to some extent from Professor Evans, but especially from Professor Magnússon today. Criticism in Professor Magnusson's case, both as to the substance and as to the methodology, or the application of the methodology for identifying customary international law. And I don't agree with these criticisms. The main substantive criticism is that the judgment raises doubts about what Professor Magnússon refers to as type 2 grey areas. That is the generally small, incidental, overlapping grey areas that are inevitably created when the equidistance line between adjacent states, as in the Bangladesh-Myanmar ITLOS case, and also in the parallel Bangladesh-India arbitral award, those are the type 2 grey areas. The type 1 grey areas, which Professor Magnússon admits are very rare, are of the kind at issue in the Nicaragua-Colombia case, where with 2 opposite states, a potential or possible extended continental shelf might, whether it can encroach upon the 200-mile exclusive economic zone continental shelf of the opposite state. And if it did encroach, that would be a grey area, which could indeed be a large grey area. I think to focus on the precise formulation of the court's first question, and just on the wording of its answer to that question at paragraph 79 of the judgment, is too narrow an approach. The court's answer to well, firstly, that answer at paragraph 79 is part of the court's reasoning. It's not part of the dispositif. The dispositif is quite specifically only about the issue between Colombia and Nicaragua. But more importantly, I think the court's answer to the legal question has to be read in the light of the detailed arguments made by the parties in writing and orally, and, more importantly, the text of the whole of the 2023 judgment as a whole. If you look at this, at the legal arguments, the judgment as a whole, it seems to me clear beyond doubt that the court was in fact only intending to address what Professor Magnússon has called the Type 1 case. As he indicated, in the 2023 judgment, the ICJ does refer to the two Bay of Bengal cases. Indeed, it refers to them at some length over a number of paragraphs. But its key conclusion for present purposes was, and I'll quote from paragraph 72 of the 2023 judgment, the court said, in the two Bay of Bengal cases, the use of an adjusted equidistance line in a delimitation between adjacent states gave rise to a grey area as an incidental result of that adjustment. The circumstances in those cases are distinct from the situation in the present case, in which one state claims an extended continental shelf that lies within 200 nautical miles of the baseline of one or more other states. The court considers that the aforementioned decisions are of no assistance in answering the first question in the present case. I don't think it could have been put clearer. And I'm surprised at the interpretation that's been put upon this judgment in this case, casting doubt on the earlier judgments of the ICLS and the Arbitral Tribunal and the court itself, perhaps, in the Kenya-Somalia case. Of course, I note that the separate and dissenting opinions of certain judges disagreed with the court, but that's normal. But I don't think that casts any doubt on the way we should read the judgment of the court. If anything, as is so often the case with dissenting opinions, they actually strengthen the decision of the court by pointing out what wasn't adopted. That strengthens the majority view. So I don't find that an argument for having the doubts that have been expressed today. Similarly, I think that the very carefully and I think judiciously drafted US announcement of its extended continental shelf claims of December 2023, I don't see that that in any way affects the view that one has of the court's judgment of earlier 2023, except, again, perhaps to strengthen the interpretation which I would have of it, because the US ignored that case as regards Type 2 decisions. It did not in any way act in a way that disagreed with what the court had done as regards what you call Type 1 decisions. And now I've only got 17 seconds left. So this is the most interesting point for me, which is whether the judgment misapplied the proper methodology for determining a rule of customary international law. I do think the law of the sea is a laboratory for understanding customary international law. It always has been. And I find this judgment a very helpful judgment in that respect. Paragraph 77 has been criticized, but even if that criticism were right, quod non, as Professor Pelle would say, it would hardly affect the authority of the court's conclusion as to the law, which, as I think Professor Magnússon has accepted, is a clear and practical solution for type 1 cases. I think the ICJ did make useful contributions to the methodology for determining rules of customary international law in this case. For example, when it said that the practice of states before the CLCS is indicative of opinio juris, even if such practice may have been motivated in part by considerations other than a sense of legal obligation. That's a useful clarification as to the subjective element of customary international law. Another useful clarification is to be found where the court said that, taken as a whole, the practice of states may be considered sufficiently widespread and uniform for the purpose of identification of customary international law. In addition, given its extent over a long period of time, this state practice may be seen as an expression, of opinio juris, which is a constitutive element of customary international law. And the court went on, indeed, this element may be demonstrated by induction based on an analysis of a sufficiently extensive and convincing practice. That's an important statement, a modern statement from the court, which I think is helpful, showing the flexibility in the discovery, the identification of customary international law. It was quoting the Gulf of Maine case, but that was a chamber decision. This is a much more recent decision by the full court. Madam Chair, that concludes my remarks, and I really do thank our two speakers for their stimulating papers. Thank you.
Thank you very much, Sir Michael Wood. I won't, of course, enter in analyzing the ICJ ruling. What I think that we are in the middle of a movie. So we are, let's say, envisaging the end of this spy story, which is not yet ended. So we need to wait future developments, and future judgments might provide us with more information about which interpretation is more founded, the critical one with regard to the ICJ judgment, or that of a sort of compatibility between all judgments so far adopted on the issue of delimitation of the outer margin of the continental shelf, when the overlapping concerns, of course, an inner continental shelf. There is also this, I think, creeping idea that there is a sort of if the claim for an outer continental shelf are with willingness aimed at obtaining a big part of continental shelf against the claim on an inner continental shelf advanced by another state, this is a situation when there is no willingness, but it happened because of the geographical situation in a specific case. The situation is a completely different one. I don't know, but I think we need to wait how case law will develop starting from these apparently opposing judgments we have so far in front of us. So I give the floor to our last discussant, Professor Lee Kim Beom. He is associate professor at Yonsei Law School, and he has had taught public international law, however, in various universities, Seoul National University, the Catholic University of Korea, Kwangwon University, and Chonbuk National University. He is an expert in maritime boundary delimitation, international dispute settlement, territorial issues, and international institutional law. So last but not least, I'm saying something obvious. The floor is yours, Professor.
Good afternoon. I am Beom Lee. I'm highly honored to be here, so I have to express my thanks to Korean Ministry of Foreign Affairs and Korean Society of International Law. I am, in fact, the last participant for today's conference, so please keep your patience just a little bit more. This conference is a very good place for meeting very good Lobdacy people, including my old friends. Actually, because of limited time, I'll add some comments or observations. I think two professors and some Michael Wood all have well touched on the last year's case decided the International Court of Justice. Since the case had been involved in the legal characteristics of the Continental shelf, it would be very great for us to discuss with the case here. We are dealing with here the development of the Lobdacy for last 30 years. The codification of Article 76 of the UNCLOS was one of the purposes during the third United Nations Conference on the Lobdacy, as you know. I think that we are now reaching to the climax surrounding Article 76. The climax means that all the issues in the context of Article 76 appear, even if we can solve all the problems. I think I have commented, I think, on 4 points. Firstly, the last year case, 2023 Nicaragua-Colombia case, was referring to the concept of the single continental shelf. According to paragraph 75, because of limited time, just I would very quickly read some sentences. The court notes that in contemporary customary international law, there is a single continental shelf in the sense that the substantive rights of a coastal state over its continental shelf are generally the same within and beyond 200 nautical miles from its baselines. What does that mean? Generally the same. Actually, and then the court said, indeed, in customary international law, as reflected in Article 76, paragraph 1 of the Convention, states entitlement to a continental shelf is determined in 2 different ways. As you know, distance criterion and natural prolongation criterion. That's why Professor Evans said just half deaths of natural prolongation. However, the court, I think, pointed out in the wrong way the concept of the single continental shelf. The single continental shelf is just defining that the inner continental shelf is the same as the outer continental shelf in the sense that there is no distinction between them in its legal character or nature. However, the court had limited the concept of the single continental shelf only in the context of rights exercised by coastal states, so that in consequence, inner continental shelf has a priority over the outer continental shelf. Actually, in fact, on the basis of the concept of single continental shelf, international courts and tribunals accept their own jurisdiction to delimit the continental shelf beyond 200 nautical miles, and then the same identical relevance circumstances can affect the delimitation both inner contour shelf and outer contour shelf. In the 1958 Convention on the Contour Shelf and in the 1969 North Sea contour shelf cases, actually we had no two separate legal continental shelf regimes. And the most famous statement regarding the single contour shelf in 2006 in the Barbados versus Trinidad Tobago case, Annex 7 Tribunal stated that in any event, there is no, in law, only a single contour shelf rather than an inner contour shelf and separate extended or outer contour shelf. But last year's case rejected this kind of well-settled concept of the single contour shelf. So I think, I doubt that the concept of natural prolongation is half dead or dead because 200 nautical mile criterion is also reflecting natural prolongation within 200 nautical miles. But differentiating 200 nautical miles criterion from natural prolongation. Last year, the ICJ had rejected the concept of the single contour shelf. That would be the first hierarchy created by the court last year. The first hierarchy means the priority of inner contour shelf over the outer contour shelf. And then I would like to introduce the second hierarchy created by the court last year. Actually, yeah, as all you know, last year the court said under customary international law, states entitlement to a contour shelf beyond 200 nautical miles is may not extend within 200 nautical miles, blah, blah. However, the court had resulted in the priority for the regime of exclusive economic zone over that of the contour shelf within 200 nautical miles. So last year's case created two hierarchies. Actually, we have not known the two kind of hierarchies within 200 nautical miles. Secondly, Professor Bjarni MAGNÚSSON already introduces last year's United States claims to outer contour shelf. Actually, yeah, Bjarni rightly pointed out in his article that US also could extend its own outer contour shelf in accordance with paragraph 2 to 7 of Article 76 of the UNCLOS, even though the US is a non-party to UNCLOS. However, at this moment, we should consider the role of CLCS. Can the CLCS review the submission by one of the non-parties? I think yes. The reason for this is that paragraph 1 of Article 3 of Annex to the UNCLOS is saying that just blah blah by coastal states, not parties or party states. That means the CLCS has a discretion to consider the submissions by non-parties, yeah, just like the US. And thirdly, yeah, already following some Michael Wood's comments. Actually, Bjarni has been talking about type 1 versus type 2. However, if I reframe this kind of versus the type 1 versus type 2 into different versus, I mean opposite states versus and adjacent versus. Actually, if I develop the opinions from Sir Michael Wood, I think just Taiwan is very related with the case with opposite states, but type 2 is related to the case with adjacent states. So I think the CLCS should play a role in making the recommendations, particular in the case with the opposite coast, to identify the existence of both parties' entitlement to the same area. And so, just in the case of, with opposite coast, I could invoke the concept of admissibility in the sense that the coastal state should submit its own information prior to the reference of the case to international courts and tribunals. We could develop the issue of admissibility. Actually, Professor Bjarni Kunoi just, I think, a real supporter about the concept of admissibility, just between regarding the relationship between delimitation and delineation. Lastly, regarding the identification of the rules of customary international, several professors, discussants could touch on this issue. But if a party to UNCLOS just follows the rules provided by the UNCLOS, that would be regarded as any evidence of state practice or opinion juris. Just in order to identify the rules of customary international law, if we use the submissions from parties to UNCLOS, I think that would be more formalistic. So if I conclude my observations, actually, our conference subtitle is Then, Now, Future, the future. So for me, then means as of 1982. So we had just learned the new definition of the continental shelf. And now, 2024, actually, as I said, we face all the issues from the definition of the continental shelf or interpretation or application of the continental shelf. Future, since this year, 2024, actually we have to sort out several issues. For example, the relationship between delimitation and delineation, just including admissibility issues and non-parties submissions to the CLCS. Actually, last year, US long way to get the continental shelf. Last year, finished from the 1945 Truman Proclamation to 2023. Just claims to the outer continental shelf. Actually, so we have to just think about the non-parties submissions or non-parties just consistent with the rules of the provisions of the UNCLOS regarding the outer continental shelf. Let me stop at this point. Thank you very much for kind attention.
Thank you, Professor Lee, for your extremely analytical comments, which have in a certain way complemented the reflections made by the speakers. Well, I think that maybe we have some time for a reply. We won't have time for a rejoinder. I don't know if there are some questions before the reply, so we will have a general reply. But anyway, no rejoinder because the time is running rapidly. Please, President Haidar.
Thank you very much. And I should say that I'm speaking more like Judge Haidar or just Haidar, not as president in any event. I take the view that the Nicaragua-Colombia judgment is in fact incompatible with the Bay of Bengal judgments. I also believe that it does not make much sense from a principal point of view to make any distinction between the type 1 and type 2 situations. I know it's academically interesting, but I don't think it is appropriate because we are dealing with issues of principle here. Either State A can extend its continental shelf into the 200-mile zone of State B or not, in principle. So therefore, I don't think we should make any distinction between type 1 and 2. And so what I think the ICJ should have done, I think they should not have asked what I call the million-dollar question and bifurcated. They should just have gone ahead and delimited based on the entitlements of the parties. And most likely, I don't know the details of this case, but I was in Bogota last week, and if what the Colombians tell me is true, then there were some weaknesses in the case of Nicaragua in terms of natural prolongation. And so simply as a matter of equity, we all know that the result, the equitable solution is the goal of Article 83. So in most cases, that would mean that, in this case, Colombia would have had full 200 nautical miles simply as a matter of equity. But at the same time, in the Bay of Bengal situations, it was the equity objective that caused the gray area to be formed. So I think we would be better served by just following Article 83, which strives at an equitable solution without taking any principled decisions on what is possible and what is not possible. In my view, I'm not convinced that there is any hierarchy between natural prolongation, continental shelf, and continental shelf based on distance. But probably in most circumstances, like in this one, the Colombia, in this case, would have full 200 nautical miles. But there are these exceptional circumstances where the opposite will occur, simply to get an equitable solution. I noticed that Sir Malcolm referred to both the Nicaragua-Colombia case, but also to the South China Sea case in terms of Article 121.3. And I think these two cases have something in common, which is that if you look at the literature following these judgments, there's a lot of criticism, and I would say overwhelming criticism of both of them. And because, as Bjarni said, he said he would be interested to see what ICLS would do if it would get a case of this kind. And so I'm not overly convinced that we would do it in the same manner as the ICJ. We might do it in a different manner, but potentially with the same outcome. So the problem in Nicaragua, Colombia, I think, is that the ICJ seems to take the view that the distance has a hierarchy over a natural prolongation. And in the South China Sea case, the problem was that, in my view, that the arbitral tribunal ignored the term rocks. It ignored that the convention uses the term rocks and not islands. And so I think there is a fault there, and at least personally, I would not be, I don't think I would easily follow that part of the South China Sea award. So I think there are some judgments that you cannot take for granted that will be followed as precedents in the future. They are only binding on the parties to the case, and it is basically the quality of the decisions that are decisive of whether they will become precedents or not. Thank you very much. And by the way, thank you for excellent presentations, all of you. Thank you.
See if there are any hands raised. Oh, yes, please, judging photography.
Thank you very much. Just two ideas to supplement what you have said. Thank you very much. You're participating in an academic exercise, so there is a lot of freedom of speech and of expression. Some remarks regarding, one remark regarding Nicaragua versus Colombia. There was the question of the economic zone present there. And that is a complex, that adds a complexity to the situation. I'm not going to judge or to argue in favor or against the decision because I'm a member of another tribunal, but I must say that that was a very important element that was taken into account and that was made present by both parties. And the second question is that notwithstanding what the jurisprudence has said, we have the possibility that states agree on something that may accept some overlaps so-called gray areas, but it is not so gray. It is just an agreement. That is the case of one of the examples that Professor MAGNÚSSON presented. And I think it is the freedom of the parties, because that is the essence of the limitation, according to the UN Convention, that parties are free to choose a line or to choose lines that accommodate their interests and their entitlements. And I think that is important to highlight. Thank you.
Thank you. I will give our speakers the possibility to reply. I think we have 8 minutes to do that. Please, I don't know if you want to start first.
Why not? I must admit I'm so jet-lagged that I only consumed a few of the points. But anyhow, I want to say one thing. And I would like to ask Sir Michael about this. Okay, if you have to read so much into the wording of the International Court of Justice, shouldn't then have said something else?
Well, thank you. And just pick up on a number of points which have been made in the in the time available, and I think they sort of all link together really, because there are different things going on here, aren't they? The first thing to note, of course, is no one ever pretended that the continental shelf has always been, shall we say, a regime that has prompted different approaches, different thoughts, heightened degree of controversies, differences, and it's wonderful to know that nothing has changed. If you're going to be delimiting, you do need the one. I don't think. Well, I think it's sort of assumed that if you're going to be delimiting anything, you actually both need to have competing entitlements. So I think that's not a bad starting point. And so then when you, and to pick up on the points that, that were just made, of course states need to be free to determine what they wish. International law is quite clear on this, particularly when it comes to maritime boundary delimitations. Agreement between states is the beginning and end of it. One of the interesting questions, I suppose, that I and no one else has asked of is whether you can now actually agree, I suppose you could, to give up, well, of course you can, to give up your entitlement to another state if in the course of a bilateral, negotiation or discussion you decide to allow a state to have, to exercise jurisdiction on a, let us call it an outer continental shelf that overlaps within an inner. That's clearly within the realm of what you can do as a state, one assumes. But, of course, international law does many different things. And at one level, it creates the space and the basic principles in which those wanting to settle disputes will move to litigation, will move to negotiation, and in those areas, naturally, it's appropriate that courts and tribunals respond to them with a flexibility that enables them to most satisfactorily answer the question. If you go back to the question posed by the court in the Nicaragua-Colombia case, it is one of absolute interest academically to me. It has been for very many years, but I absolutely get it, that in these situations, sometimes it's better not to actually approach it from that way. And as I said, in relation to baselines, for example, it's long been the case that these are one of the flexible tools that are available to a court, a tribunal, or negotiators to be able to produce a settlement that sort of works for everybody. And in those circumstances, coming to solutions that work for everybody is absolutely fine. But there are other occasions when we expect law to do something different. And that is actually give us some degree of clarity about what actually the law is, and therefore what actually can be achieved. And in brief, I'm tempted to say that I'm delighted and happy that Sir Michael is entitled to be as wrong as I am on so many things, because I do feel that there are a number of points. In some ways, I think we're a lot closer to each other than meets the eye. Is the convention a living instrument? Yes, of course it is. Nothing wrong with that. The problem is that it's, in my view, got too many different lives, and it's trying to live them all at the same time, and it's sort of leading to a bit of family feuds. If we use the example, for example, that we had brilliantly this morning, that Anna distilled out of the discussion between Tara and Anna, they could both easily see that the territorial sea was not delivering what we want it to deliver. And as was pointed out, Tara wanted to take things out. Anna wants to put it in to the, to the territorial sea. You can't really do both, but we need a solution. And so we may have to think a little bit more about what is appropriate, and so on. I don't know that it's so terribly helpful to be so unclear about what key terms also means all of the time. There are times when creative ambiguity, particularly in negotiation and in dispute settlement, is really important and it's really helpful. But there are others when I think it's not. And so if we take Article 1213, for example, I think one of the results of the Nicaragua-Colombia case is that it has made it more difficult to live with creative ambiguity, because if you take the point that you have to have title before you can move to a delimitation, we now need to know, almost as a condition precedent, whether something can or can't generate that extended maritime zone before we can move to the next stage of knowing what is the area to be delimited, where the 200-mile limit falls or whether it doesn't fall, etc., etc. I'm not at all reluctant to accept that the law is as set out in Part 6 of the Law of the Sea Convention on the Continental Shelf. It absolutely is. I think the point in part is that is now becoming the problem, but I'm not saying that it isn't what it is, but you can't just say that because it is, things have got to be accepted uncritically. If we did that, we'd still have the 1958 Convention definition of the continental shelf, because at a point, that was it. Things move on. And I suppose, I must draw to a conclusion, but, I'm not talking or calling for a bonfire of the rules. What I'm simply doing is doubting that the rule book that was written basically for the problems and issues of the 1970s is ideal for solving the problems which we have now identified in the 2020s. It's not that it can't do it, it's not probably that we don't have to do it, but it's just not the ideal lens through which to be able to tackle some of the problems that I believe we really do have to face. And again, perhaps unlike Michael, I think that there are problems that we do have to face, and we just can't let them all just wait and see and deal with them as they arise. That's responding to the problems, not actually looking forward to those problems, just like the original of the continental shelf was. We can see there's a need to do something. What's the regime that can help address it? At the moment, it's not helping address some of the real problems that we see, but it is what it is. Thank you.
Thank you. I think that we have reached the end of our working day, and of this panel as well. So I wish to thank the participants for this very active and debate and in-depth and critical analysis. And I wish to thank the audience, which patiently has followed our discussion, sometimes highly technical, but the delimitation issues stimulate such a technical reflections. And I wish you all a pleasant evening, and for those attending, a nice reception. Thank you. Goodbye.
Thank you, Judge CARACCIOLO, and thank you everyone for enlightening speeches. And let us give all the speakers a big round of applause once again, ladies and gentlemen, for their exceptional presentations and discussions.